Stevenson. I think I remembered everybody, but if I didn't, oh, Miss Patricia Hargett, thank you for not having your regular meeting today and for allowing us to have this session. Amen. So if I forgot you, I'm sorry. I love you. It's not intentional. So thank you to everybody that is in this place today and that took the time to be here. Amen. Now we have a sign-in sheet that's gonna go around. Attorney Robbins sent me that, so we want to make sure that we fill it out. There's also an appointment sheet there as well. Excuse me. There's an appointment sheet. If you want to set up an appointment with her, we have that sheet as well. Also, there is a QR code. Now, if you got vision issues like I do, and you're not able to see the screen very well, we have a QR code that you can scan on your phone, and you can see the presentation on your phone. Somebody say amen. I try to cover all bases, okay? We will have a question and answer period whenever Attorney Robin, you can make that call whenever you want to take questions and answer. We have a mic stand. We have a mic stand. I didn't know what that was. We have a mic stand that will be in the middle that you can go up to the mic stand and ask your question. I think I covered all the bases. Before I take my seat, Deaconess Judy Brown is going to come forward. She's going to open us up in prayer. And then after that, we will hear from Attorney Robin. We want to silence all of our devices during this session. And also, Attorney Robin, thank you for being here. We have a token of appreciation for you. It's sitting up here. Also got you a little bit of lunch money that you can share with your son. Amen. To God be the glory. Thank you for all you do. Amen. Amen.
Let us go to God in prayer. God, first of all, we just thank you. We lift you up. We praise your name for who you are, but also for what you've done for us all during our journey. Lord, we ask that as the sister presents this class, that we take what she gives us and we take it in our hearts, in our minds, and we don't just allow it to just sit there, but that we take it and we use it for ourselves, for our families, because we know that one day we're all going to leave here. And we want to make it easier for our families and our loved ones when we leave this earth. Lord, put it in our hearts, put it in our minds, put it in our spirits to do what we need to do and to receive the knowledge that's going to be given to us in your name, Jesus, so that you also may be glorified and that we share it with someone else. In the name of your Son, Jesus, amen.
I should be okay. Thank you so much. Okay, thank you, sir. Good afternoon, everyone. How are you today? Thank you. My name is Robin Hicks Gwynn, and I am the founder of Hicks Gwynn Law. We have offices all over the state of North Carolina. And the one question I think I forgot to ask was, how do I click through the PowerPoint screen? He's got me back there. Thank you so much. All right. And we'll go back one more slide. Yes, sir. Thank you, because I would like to thank the Seniors on the Move Ministry for allowing me to be here today. It's really nice to be able to meet people in the stage of life that they are, wherever they are, because it looks like there are a number of people who are in different phases of life. And so the presentation that I'm going to give today will hopefully be able to meet you where you are and allow you to make some plans moving forward about how to plan for your legacy in your life. The next slide, please. So we have offices in Charlotte, which isn't too far away, in Raleigh, and also Wilson, North Carolina. But we also meet our clients where they are, which often means that I'm meeting people at their kitchen table. I did that earlier this week, or in the hospital. I'm doing that later on next week. And so wherever you are, or if you have a friend or a family member, we are able to meet them so that they can make their next phase of life plans, regardless of where they are in that phase of life. Next slide, please. So the type of law that we focus our practice on is estate planning, estate administration, which is also known as probate, minor and adult guardianship, and then also business succession planning. So we're going to talk about all of those today. And at any time, if you have a question, please do stop and ask me, because I'm happy to answer those questions. I want to make sure when I leave here today, you have a really good understanding of what you need to do next, okay? Next slide, please. And so I don't know how many of you know, but the Bible actually talks about estate planning. There are a number of passages in the Bible, and I'm not going to preach today. I don't have the credentials to do that, but I do want to share just a few scriptures to leave you with. And Proverbs 15:22 says, "Plans fail for lack of counsel, but with many advisors they succeed." And so although I'm here today as an attorney, there are other advisors that you should probably talk to when you're making your plans. Those are tax professionals, your doctors, and then your wise counsel is what I call them. Your wise counsel are the people who are helping you do life, whoever that might be, whether it's your children, your spouse, your siblings, or your friends. These should also be people you're speaking with when you're thinking about making your next phase plans. Another scripture is Psalm 24:1. "The earth is the Lord's and everything in it." And so what that means to me when we start talking about estate planning is everything that you have amassed over your lifetime, it's not yours, it's God's. So when you decide how you're going to pass that on, it is your responsibility to be a good steward, which the Bible also says. And so being a good steward is making sure that whoever's going to get what you're leaving behind is going to take it, they're going to multiply it, they are going to take care of it, they're not going to squander it. So sometimes that means that you're not leaving assets behind to people who are relationally the closest to you, but you're leaving them in the care of someone who's actually going to do what's right. And then Proverbs 13:22, "A good man leaves an inheritance for his children and his children's children." So that means when you're thinking about estate planning, you're not just thinking about the next generation, but also how the following generation is going to be impacted. So if you have grandchildren, that's the generation we're talking about. We're not going to leave them behind. There are other scriptures in the Bible that talk about what you do today will affect a number of generations thereafter. And so when you're thinking about how you're going to leave your assets and your legacy, because those are two totally different things, you want to think about how you're going to impact the next few generations. Next slide, please. So I just want to talk about some statistics in our community. So in a group like this, I usually say, look to your left and look to your right. Only one of you probably has a comprehensive estate plan. And in our community, when we talk about estate planning, that number is a little bit lower than the national average. We don't make plans. In our community, we're either waiting too late. Sometimes I come and visit with people who are too scared to do it because they think the thought of thinking about their passing, it makes them nervous. And I understand that. But what I'm here today because I want to change that. It's not a scary thing. It's actually something that should make you feel very empowered because we're making sure that you're being taken care of during your lifetime, and then the people that you love are also going to be taken care of as well. And when we start to talk about women, I'm going to make some distinctions here. and we'll have some other discussions about this in the next few slides. Women account for 55% of the workforce, but they only hold 29% of chief executive offices or upper level management roles. Next slide, please. And then for our men, our African American men are usually less likely to have an estate plan compared to their female counterparts. So I don't know why that is, men, but you're not making a estate plan. So I'm glad to see some men here today. The life expectancy for the average African American male is much lower than his male counterparts and also his white counterparts. So when we think about this, what does that mean for African American men? It means they are leaving their wealth behind for their wives and their children to use. And also, in today's society, many people, if they've been divorced or widowed, are not remarrying. So the likelihood that they're actually leaving their resources to a spouse is also lower. Next slide, please. So for our women, we are 3 times more likely to become a widow by age 70. Why is that? A lot of social norms. Many women marry men who are older than them, right? So there's that age disparity. Women are known to take better care of their health. That's another reason. But also, women spend at least 10 to 20% less time in the workforce. So we already talked about that. And that's for a myriad of reasons. We take time to take care of the children, take care of home. Or maybe we're taking care of a sick loved one and never fully re-enter back into the workforce. But either way, we're spending less time in the workforce than our male counterparts. So that means when we have completed our work and we're ready to retire, we have less money than our male counterparts. We haven't spent as much time in the workforce, so we have not amassed the same level of retirement and other resources as our male counterparts. Next slide, please. So what does this mean? It means that once we reach the age of retirement, men typically have more money because they've invested more time. It also means that women are more likely to make the final decision between a couple with how assets are being distributed. And it also means that in today's generation, you are either more likely to leave behind your assets to children and grandchildren or someone who's not related to you at all. Women are having less children or no children at all. So these are things that we want to consider when we start talking about estate planning. Do I have any questions so far? Okay, next slide, please. So why is estate planning important? It's going to allow you to maintain control of your health and your assets. It would allow you to determine who and how those assets are managed during your lifetime and also once you've passed away. I don't know how many of you are familiar with the court process called probate, but it's lengthy. And there are a number of ways you can actually avoid probate if you make pre-planning. So we'll talk about that today. And also, if you have an estate plan, it could help your loved ones minimize whatever debt they may have to enter into to bury you, to help cover medical expenses, and then whatever else might come thereafter. It also allows you to build generational wealth. So if you're thinking meticulously about how you're going to leave your assets and your legacy behind, then you're able to help the next generation hopefully go a little bit further than you did. And then, I'm sure it's not your family, but a family that you know just couldn't keep it together after mama passed away, after daddy passed away, and those family bonds were forever severed. Well, if you make an estate plan, you might increase the likelihood that a few less people will fight. Now, they may not be happy with what you put in the document, but you won't be hearing. Okay? And I see this happen all the time. And making an estate plan makes it clear on what your intentions were. No one can argue with that. And lastly, I'm hoping that when you make an estate plan, and my clients tell me this all the time, they have peace of mind once they leave me because they know what's going to happen next. They know what their future is going to look like, and they also know what their loved one's future will look like as well. Next slide, please. So during my initial intake process, I learned a lot about my clients. And I often tell them, it's not fair for me to learn so much about you and I don't tell you anything about me. So I'm going to tell you about me today and why estate planning is important to me. So you'll see a lot of pictures on the slide. These are all major milestones in my life. So the first slide you'll see, that is my high school cheerleading squad. When I was 18 years old, we won a championship at Disney World. And so that was right before I went off to college. And then I went off to law school at North Carolina Central University. Any Eagles? All right. And then shortly thereafter, I married my husband, Lambert. And then we had our oldest son, Robert, who's sitting there in the back. And that is the slide below, you will see of my mom, my sister, Lambert, and I when we actually found out that we were pregnant with Robert. And that next slide is of the maternity picture when we were pregnant with our youngest son, Henry. And so all of these are major milestones. And I'm sure a number of you have shared at least one of these milestones with me. You've either gone to college, you've had children, you've gotten married, or achieved a major goal that you set out to achieve. Well, for many of these life events, my dad was no longer with me. He passed away shortly after that cheerleading picture. He passed away from lung cancer. But all these major events that I had in my life, he left behind trinkets and notes. So I could still feel his presence during those moments and imagine what he would have thought if he had taken that journey with me. And so I want to encourage you to not just think about the stuff you're leaving behind, but also the legacy that you're leaving behind, the life lessons and the wisdom that you can also impart on other people through estate planning. So my dad decided to leave behind notes and trinkets. We also assist our clients with doing videos, taking pictures, or writing letters. That is also a part of estate planning. And so if you do have important life lessons, maybe the next generation that you want to pass it on to, they might not be quite ready to hear it at the moment that you're no longer here, but they can hear it later on when they're ready. And you can have other ambassadors in your life to bring that message to them. Next slide, please. So I encourage you, when you think about the void that you're gonna leave behind for your loved ones, also think about what other things can I give them? What other message can I give them other than just my stuff? Next slide, please. So we talked around what estate planning is, but I want to make sure everyone's sure on exactly what estate planning is. So it is making a plan for the future. It is making a plan about your health and then also your assets. So those two combined is a comprehensive estate plan. Next slide, please. So in the state of North Carolina, the legislature has actually codified an estate plan for you. Oftentimes it's not what you want it to be, but if you pass away without any estate plans, the doctors, the banks, and the court will follow what the legislature has already set in motion. Oftentimes, what it does is it splits assets between a husband and wife. So now the surviving spouse will share assets with the children. That is usually not what most people want to happen, or at least not within the percentages that the legislature has set in motion. If you don't have a spouse, it leaves it to your children. The caveat here is many people, or I'll say men, may not have legitimized their children. So if you haven't done that, and it doesn't mean that you are a bad father, it just means that you have not signed a document that has been notarized stating that that individual is your child. I see many instances where a father has taken care of their children, but they haven't signed a document stating that it's their child. So it's common knowledge, and you were a wonderful father, but you didn't legitimize those children. So what happens is your children cannot inherit from you, and you also cannot inherit from them. And that's something really important that I want women and men to know, because that's a very sad moment for me when I have to share that with a mother or a child. Next slide, please. So the only way you can actually overcome the estate plan that has been made for you by the state of North Carolina is to make your own. And the documents you see on the screen, the 5 documents, are what makes up a comprehensive estate plan. That is a last will and testament, a trust, a healthcare power of attorney, a durable power of attorney, and a HIPAA form. And we're going to talk about each one of these documents in more detail. Next slide, please. So the first document we'll discuss is the last will and testament. This is a document that's drafted during your lifetime, but it does not become effective until after you've passed away. In this document, you're appointing an executor. This executor will be the person who will manage your assets before the court, because we have to file your will with the court, or if you don't have a will, we're still going through this probate process. And what this individual is doing is taking an inventory of all of the assets you've amassed over your lifetime at the point that you've passed away, and then they're first paying off your creditors, and then they are leaving what's left behind to your beneficiaries. In some instances, there is nothing left for your beneficiaries once we've paid all of your creditors. Under this process, real property actually does not pass through probate. And what I mean by that is, even if your will designates who gets a house, right? Because we can do that. We're transferring personal property and real property through this document. But what I mean is, the court is not overseeing what happens next with that real property. We're reporting that it exists, but we're not doing anything else with it, unless we have to petition the court to bring that house into the estate to satisfy your debts. And many people don't know that. So if one of your major goals is to protect your house, I usually recommend that the will is not the only tool that we use, okay? For that very reason, that house can be used to pay off your creditors. Yes, ma'am.
Those creditors have to be paid, because my husband passed away recently. I just sent the creditors a copy of his death certificate, and I don't have to pay anything.
So it depends on what the debts are. There are some debts. Yeah, a lot of credit card companies will waive that, that fee, but depending on how high they are, they may not. And I've seen it where some credit card companies, because there was high revolving debt. So for example, the same company that works with Dillard's also works with Belk's, also works with, so you see where I'm going there? So maybe you could have various credit cards, and actually the underwriter of that debt is the same company. So maybe you just have a little bit here and there, but when you add it all up, it's a lot. I've seen where creditors have actually forced the sale of houses to get what they want. And so also, if there's a surviving spouse, sometimes a lot of people don't know, but the spouse doesn't absorb your individual debt. But they could catch a lot of people because they won't tell you that. They'll just let you keep paying on your deceased spouse's debt because they know that they can get the money from you. Do we have any other questions?
I wasn't too clear about the real estate property and the personal property.
Yep. So personal property is anything like your money, your clothes, anything that's inside your house, right? Your appliances, your tools. Real property is land and the structures that sit on it. And personal property is literally anything else that's not those two things. So real property is your house, if you own a building, if you own land, If you have a stake in heirs property, which a lot of people do, that's your real property. Did that answer your question?
Kind of, but I didn't understand if your debt's paid off, you left the house in the will,
Mhm.
but the county doesn't bother your real estate property until you sell it or get that fixed out?
So this is what happens when you pass away. When you pass away, you either have a will or you don't. You either have a trust or you don't. And it'll make a little more sense as we go along, but I do want to answer your question. So when you pass away, your house instantly actually becomes the property of your beneficiaries, whoever they are. So your beneficiaries are either set by statute or set by your will or your trust. So those individuals are already established, whether you established it or not. And if they do not assume their responsibility immediately, like paying taxes for the upkeep of the house, they can certainly lose it. And yes, the county, the city, or the state will take it if they don't pay the taxes on the house. I see that happen all the time. And that's sometimes because people don't know that they've inherited something, or they're not ready to inherit something, which is usually the case, or they don't understand the responsibilities of inheriting something, which is why we want to make an estate plan. And we don't have to discuss all the details, but you want to make sure that when you leave here, the people who are supposed to inherit from you know that they're receiving something. You don't even have to tell them what it is, but at least they're going to start asking people questions. What do I need to do next, right? And with our firm, you get the benefit of them being able to call me and ask me what needs to happen. So they get a 1-hour consultation with me when you pass away or you become incapacitated, so they know what to do next. Does that answer your question? Okay. Yes, ma'am. And we're going to talk about a trust in just a little bit. Do we have any other questions? Yes, ma'am.
When you mentioned in the very beginning about consultation with folks, you mentioned tax professionals, attorney, but I didn't get that third.
Oh, your physicians, so your doctors, you need to talk with them. And then also I call them your wise counsel. So whether it's a friend, a family member, a spouse, whoever you are choosing to bounce ideas off of about how to move forward with life. Next slide, please. So our next slide discusses the process of probate. And I think this is very important because most people, unless they make a trust, their assets are going to flow through this process. This is a court process, which in the state of North Carolina is beginning to take a little longer because people are moving here every day. More people are moving to the state of North Carolina, but also because our court system recently transferred over to a digital system. And actually here in Gaston County, you guys will convert to that system on the 16th of October. So you haven't started it yet, but it usually adds on a little extra time to this probate process. That can take anywhere between 6 to 18 months, depending on what's going on in probate. And so that's a lengthy time for someone to have to wait to receive assets from your estate. So we'll talk about ways that you can avoid probate, but I want you to know probate is not free either. You have to pay to file the documents. The court takes a percentage of what you're leaving behind as well. And so when we're done, after you're done probably paying professionals, like you need to get your taxes done, they may hire an attorney, they are receiving significantly less than what you intended, okay? And so if you can avoid this process, you want to, because think about it, someone has to do this right after you've passed away. So they're also grieving your loss, and many people come to me because they find the process to be either too difficult or they cannot emotionally handle the process at the time. Does anyone have questions about probate? Yes, sir.
So, if you have a trust or a will, you don't have to go through it.
So with the will, you still go through probate. You file the will at the courthouse, and then they'll open up your estate, and the court is overseeing this entire distribution process. It is public. Anyone you know who has passed away and needed to have assets distributed, you can go down to the courthouse and you can see exactly what their beneficiaries received, if they did, what creditors had to be paid. So if you don't want for people to know what happened to all of your stuff after you pass away, you certainly want to avoid this probate process, okay? And if you do not have a will, you will still go through this probate process. There are just two tracks. One is all probate. There's one track where you have a will that's saying exactly who is supposed to get your stuff. And then there's another track with no will. It's called administration, where you don't have a will, so we're following what the state statute says about who would get your stuff.
What's the length of time on either one of them?
They're the same.
18 months, so the one with the will, is it less?
No, the track is the same. The only thing that's different is actually one form that you file. There's one form for people who have a will and a different form for people who don't, but it's actually the same process. Okay?
And we're gonna talk about getting around it?
Yes, sir, we are. Yes, sir.
I just had a quick question too. I got the will, right? It's, been processed at the courthouse and everything.
Okay.
But I was listening to what you were saying about the responsible, because I got 3 sons.
Mhm.
And I got them like 33, 34%. And I'm sitting there thinking, not just putting nobody out, you know, that maybe is there any kind of way I could, once I already got that done, to kind of change the numbers on the percentages?
Oh, absolutely. You can go back and change your will at any time. As long as you're still alive, you can do that. If you have recorded it or filed it down at the courthouse, you and either the attorney who drafted it are the only people who can take it out. Nobody else can take it out until you've passed away. So you have to go back and go get that will and have changes made. That's what you would need to do. Any other questions? Yes, ma'am.
You mentioned something about, the collection of anything that's due.
Mhm.
My question is, I lost my husband last year.
I'm sorry.
Last year. I got a call about, a loan, and because it was our second marriages for both,
Mhm.
he had his stuff, I had my stuff. And
Sure.
They mentioned something about a loan to me, and I said, I don't think so.
Mhm.
So I called the bank.
Mhm.
They were saying, yeah, you did sign something. No, I did not. I knew I didn't.
Mhm.
So when I contacted the bank in person, they checked for me and I hadn't signed anything.
Right.
Why did they do that?
So it could have been that the bank was confused. If you are the second spouse, maybe they didn't understand that you were someone different, right? I try to give people the benefit of the doubt. But likely what happens in these instances are the people you're talking to on the other end, they are responsible for recouping funds for their boss, right? So they will do that by any means necessary. And they may not be told specifically to do that, but it is certainly written within the company culture to recoup money for me so that you can keep your job. And so I have literally sat beside some of my clients where I've heard fraudulent things happen. And so just even if you don't retain an attorney, before you start paying debts, at least get a consultation. Because a consultation to ask about those debts, because in a number of instances, you may not need to pay those debts, especially if you are not the co-owner of whatever that person signed for. And if you go to the courthouse, they'll often tell you that, but they see a lot of people throughout the day, so sometimes you may not hear it. So I want to make sure you hear that here, that you are not responsible for anyone else's debt unless you are a co-signer or guarantor on that debt. Okay? It doesn't matter if it's your spouse, your child, you are not responsible because you did not personally recoup that debt. You didn't incur it. It's not yours. Yes, ma'am.
I've always heard that if you were married to a person for 10 years or so,
Mhm.
even though you're divorced
So that becomes a little more complicated for a few reasons. One, because you can get a divorce without actually separating all of your assets. That's possible here in the state of North Carolina. But also, if you have co-signed for something, but your relationship to that person has changed, it doesn't change the fact that you're still on the hook for that debt because you signed for it. So if you signed for it, it is your debt as well, okay? And so if you sign for, maybe you signed to be a co-owner or a guarantor on a car with a child and that child passes away, you still owe that debt because you were a guarantor, okay? Same with the spouse. You guys go buy a house together, one spouse passes away, you get to keep the house too because it's yours, but guess what? You got all the mortgage. That's all yours too. So that's how the debt works. Any other questions? Okay. Next slide, please. So now we're going to talk about how to avoid this probate process. And I usually bring a box with me, but I have a bag. So I like this to be illustrative. People understand the process a little bit better. All right, so I have a little makeup bag up here. It's empty. See that? Okay, I'm going to borrow the church's stuff up here just to be illustrative. I'm going to give it back. So I want you to think of a trust as a box or a bag, okay? You can put things in. You will put things in. Now, depending on who's holding the bag, you get to control who's going to hold the bag, okay? I can hold the bag as the person who created the trust, or someone can hold my bag. Or I can let someone else hold my bag, okay? Whoever is holding the bag controls everything that is in the bag, okay? So that's the first step of understanding a trust. It's not complicated, just most people don't explain it in a way where it's understood. They want you to think it's complicated, okay? But it's not. So a trust is really, it's a relationship between the trustor, that is the person who is creating the trust, okay? And the trustee, that is the person holding your box or your bag, okay? So, next slide, please. So, there are 4 different types of trust. Really, there are dozens of types, but they all fall into one of these 4 categories. A testamentary trust, that's where you have trust provisions that are included in a will, a last will and testament. Then we have a revocable living trust. That's when you are the trustor and the trustee. So you make the trust and you are holding the bag, okay? Then there's an irrevocable trust. That's one that cannot be changed. You, as the trustor, you create the trust, you pass your bag or your box to someone else to hold it, okay? And then there's a special needs trust. This type of trust is for individuals who have special needs and are receiving Social Security, disability, or some other type of government benefit where if they have too many assets, those benefits will be disrupted. So there's a special trust we create for them so that they can keep their benefits and also benefit from the trust that you create for them, okay? So we're gonna talk about these different trusts more specifically, and I want you to ask me questions if you don't understand something, okay? Next slide, please. Okay, so that testamentary trust that we talked about, we've already talked about a will. These are provisions that you add to the will to create a trust. You still have to go through that entire probate process that we talked about, and then the provisions of the trust are honored. I don't like this type of trust because one of the benefits to having a good trust is that the provisions of the trust are kept private. And so if you have a trust that is included in your will, you have to probate that document, and that document becomes private. So whatever you leave behind for your beneficiaries, now everyone knows you left them $1 million. You left them your house. You left them your car, your insurance policy, whatever it is getting reported on the accounting that you have to file with the court. Okay? So it's like putting a target on your beneficiary's back that they now have money. This type of trust is good for leaving assets behind to a minor child, and you want them to have their assets when they turn 18. I don't advise that because most 18-year-olds cannot handle large lump sums of money. And so the reason why I say this is not a good vehicle to transfer assets is because this type of trust is not meant to last for a long period of time. Probate is not meant, beyond those 18 months, the court starts to get mad at us if we leave that probate open. It's not meant to last for a long period of time, okay? Next slide, please. So what I recommend is potentially a revocable living trust. With this type of trust, you, the trustor, you create the trust, you can craft special provisions, and I'll help you do that, on how your beneficiary should receive assets. You control the assets after the trust is created. You and the trust are almost one and the same. The tax ID number for that trust is actually your social security number. Once you become incapacitated or you pass away, this trust becomes irrevocable, okay? Because you and the trust are one and the same, which means that the government would look to see what's in your bag and say you have control over those assets. So you will likely not be eligible for Medicaid, which right now, the monthly limit is $2,200. Okay? You get one house, you get one car. We won't go through all the details of that right now because I want to make sure that you understand the principles behind the revocable trust. Okay? So you're still controlling the assets during your lifetime, and because of that, the money or the other assets, your house, your car, your pension, it's all still controlled by you. So you're likely not going to be eligible for Medicaid unless you're receiving less than that $2,200 per month, okay? The benefit to this trust, though, is you still control everything. A lot of people still like to have that control during their lifetime. Next slide, please. With the irrevocable trust, again, you are creating this trust, you're putting your assets in here, and you can continue to add things to the trust over time. But you're giving control and responsibility, to someone else. This person is controlling how those assets are spent based on the rules that you've established in the trust. Now, for some of these irrevocable trusts, those assets can still benefit you. That trust could pay for your home. It can pay for upgrades to your home. Like as you age, maybe you need a ramp instead of steps. Or maybe you need a new roof. Maybe you have some type of medical procedure that's going to be costly. Those things can be paid for with the assets from your trust, the irrevocable trust. But again, now you don't have anything, right? I'm not holding anything. Someone else is controlling everything that is in my bag. So no assets are attributed to me, and actually in an irrevocable trust, it has its own tax ID number. It gets its own EIN. And because of that, you may be eligible for Medicaid, depending on how many of your assets you have placed in the trust and what you have left behind. Another benefit to the irrevocable trust is that there is a step up in basis where you don't pay taxes on it. Now, most of the people in this room have had an opportunity at some point over your life, whether you've done it or not, to purchase a home, or you likely understand the concept of equity in a home, right? So I'm gonna go based on that assumption. So let's say here in Gaston County, I know a lot of things have been changing here. Gaston County is booming. People are moving here. So if you purchased the house 20 years ago, you may have been able to purchase that house for $100,000. You cannot do that in Gaston County now. So I'm gonna say 20 years ago, I purchased the house for $100,000. It is now valued at $500,000, okay? Now that's happening in Charlotte, so these are, I don't know if that's happening yet here, but I know that the numbers for a lot of people who have even purchased houses within the last 5 years here have doubled, depending on where you live, okay? So I have now $400,000 in equity that I have incurred over the last 20 years, okay? If I place that house in the trust in the beginning when I purchased that home, I'm not paying taxes on that the $400,000. You know how your property taxes increase? Okay, I don't have to pay the taxes on that. I, Robin Hicks Wynn, do not have to pay the taxes, okay? And when I transfer that property, because I'm gonna transfer it through the trust, I'm not gonna transfer it and give it to my children outright, okay? They're not paying for that increase that they earn. Okay, that's called a step up in basis. That is one of the benefits to an irrevocable trust, right? So we've talked about the Medicaid benefit and we've talked about the step up in basis. But what a lot of people don't like about this type of trust is you're not controlling what's in the bag, okay? You get to make the rules about how the money is spent or how the assets are used, but you don't get to control it after that. You don't get to change the rules after you have created that irrevocable trust. Now, if you have set rules such that you can have the trust be essentially eradicated or stopped or closed, you can do that, but you would have had to think about doing that when we were drafting the trust. This type of trust cannot be changed, okay? Does anybody have questions about the irrevocable trust?
I do.
Yes, sir.
So I look at a lot of properties.
Uh-huh.
And I noticed that, people are putting properties as far as land in irrevocable trust, their kids and stuff like that. So that's the purpose of that, to kind of shelter the taxes and stuff like that?
It is. It's a shelter, but also an irrevocable trust is one of the only few trusts that would allow you to protect your beneficiaries from divorce, bankruptcy, and creditors. Because the only person controlling that asset is the trustee. Then let's say you have a child who's a spendthrift. They like to just spend. You can put in the trust, this child will never receive this benefit outright. So maybe they won't receive the house outright. But guess what? They can go and borrow against it. But because they don't have control over that asset, the trust will not have to pay back that debt. So this is how the rich get rich and the poor stay where they are, right? Because what they do is they keep that principal asset and it stays forever available for use to get other collateral, to get other resources. But we keep that principal asset. So that's what you can do with an irrevocable trust. But also, you know, sometimes we go into it thinking it's gonna last forever and it doesn't. But what you don't want is that your in-law takes half of what you have or are for, right? So if you place assets in an irrevocable trust, that spouse would not be able to take that 50% or whatever.
1, 2. 1, 2, 1, 2, 2.
Yes, sir.
Real quick. So which would you, recommend that we take? The irrevocable or the revocable?
We're gonna talk about that
Okay.
in the end, and it's gonna be based on what phase of life you're in. Not your age, but what phase, okay? Yes, ma'am.
Am I to understand correctly? You're
wanna make sure you understand. There is nothing you can do other than tax strategy to prevent yourself from having to pay your taxes. So by no means am I saying if you get this irrevocable trust, you don't pay taxes. So the county or the city taxes, those are always paid, okay? What I'm saying is you don't pay capital gains tax, right? So Robert, my son in the back, I have a trust for him and his brother Henry and whoever this future person will be. And I'm transferring all of my real property through those trusts because as the equity in those homes continue to increase, there has not been a transfer from one person to another. So there is only taxes, those county, city, state taxes that you might pay, but there's no capital gains because I haven't made a transfer from one person to another. Does that make sense? So those are the taxes that I'm talking about. Usually when you transfer taxes from real property from one person to another, you're paying those capital gains taxes as well, okay? That doesn't happen inside of a trust, an irrevocable trust. Good question. Yes, ma'am.
So if you did the trust, the house was 100,000, now the value is 500,000. What property tax are you paying? The 100,000 tax on that or tax on the 500,000?
Well, you're not paying anything, right? Because when you place, so at whatever point you're placing the house in the trust, you lock in. That's the number you lock in, right? So I talked about 20 years, maybe the house was only worth 300,000 at year 10, and that's when I decided to do it.
Right.
That's the number you're locking in,
Okay.
okay? Yes, ma'am.
What is the, you talked about Medicaid plan
Uh-huh.
from one versus the other,
Mhm.
revocable or irrevocable. What was that number? What is
Oh,
the?
So it's about, and this is an approximate number, because it changes every year, but $2,200. So if you have more than that in the bank, you'll have to do what's called a spin down. I don't know if you've heard people talk about that. So you'll have to spend down all your money until you get to that threshold number. Or get rid of all of your assets until you get to that number.
You mentioned that the amount changed, at one time it was 2,000, was it not?
It was.
So when you said 2,200, I'm thinking.
Yeah, it goes up every year. I've never seen it go down, but I guess it could.
So is that liquid act? Is that liquid?
So there's a formula that they look at, and it's based on whether or not you're married or single. 2,200 in cash or liquid assets. If you're going to stay at home, then you can have a house and you can have one car. There's another formula we use to get us to a similar number for a husband and wife. It's a little more complicated to explain, but just know that if you can essentially apply those same numbers to 2,200. That changes though. If you go to a facility, you have to stay there indefinitely, you can't have a house. So now we have to sell your house, and what happens is once we sell your house, you have to spin that down before you actually become eligible for Medicaid. So if you do this pre-planning, we're preserving the house, you're eligible for Medicaid, and we don't to rush and do a spin down is really high. Because Medicaid will look back 5 years from when you need it to see how much money you have. And if you had too much money 5 years ago, you have to pay for your care for some time. Like, there's a formula for that as well, but you will not instantly get Medicaid. And so that's why estate planning is important. Yes, ma'am.
For instance, I've done a will, and my nephew is my beneficiary, but he doesn't live in North Carolina State. He lives in New York. But the laws down here are different.
They are. And that's okay. What he will be forced to do when he presents your will to the court is he'll have to get what's called a resident process agent. That process agent will be accepting service for any communications that he might receive from the court. Some courts encourage you to get an attorney, but you don't have to get an attorney. You just have to have someone who would serve as a resident process agent. And you can actually find those on the Secretary of State website. They have a tab for resident process agents. But I have plenty of clients who are out of state, and they retain me because they want to make sure I essentially handle the full probate process. All they have to do is sign documents and send them back to me. So that won't be a problem.
So, I see in our community, they talk a lot about wills. And probably several of us have wills. And so listening to you, sounds like, at least I'm getting this, either the wills really don't matter, or if you got the will, the person who is being left in charge of the will, you have to let them know how they have to take care of it through probate. And they need to get somebody, an attorney or someone as yourself, to help them go through probate, which will make the process a lot easier.
I think so. I think having an attorney does make the process easier. I also think that you could avoid probate by getting a trust or making sure that you don't have any assets in your name towards the end of your life. And we'll talk about that because it doesn't necessarily have to be through a trust. I think that the trust is the best vehicle to do it, but it's not the only vehicle.
Because I'm not sure of all those 4 trusts. I'm not sure which one
Is the best? Yep. And we're going to talk about that too. I won't leave you hanging, I promise. All right, you guys ready to move to the next slide? Yes, ma'am.
Did you touch on the special needs trust?
No, ma'am, I haven't gotten there yet.
Okay.
Next slide, please. And here we are. Okay, so the special needs trust, again, is a type of trust that's created that would allow someone who's receiving benefits for disability to still receive those benefits. And how that works is the special needs trust is an irrevocable trust. So remember how I told you it's created, someone else is holding the bag. So you as a parent or a grandparent or a friend can create this trust for someone else you intend to leave assets for, and you can place assets into that trust. You are holding the bag for that individual or allowing someone else to hold the bag for that special needs individual. So the special needs individual can also create a special needs trust for themselves. When they do so though, they have to pay back the money that they placed in the trust. So if there's money left over, or, well, essentially, yes, if there's money left over in that trust, it goes to pay back the government. And that's because those are called first-party special needs trusts, where they're essentially receiving benefits. While they have already been receiving government benefits, they're receiving benefits from some third party, right? But they've already been eligible for Social Security and disability. And anyone who has gone through that application process knows that it is want to avoid that process.
Somebody must be calling in for a question.
Oh, okay. No, okay. So with this special needs trust, it's just enabling someone to continue to be a beneficiary of a trust and receive benefits. So some of the things you can spend this money on is housing, additional supports, which oftentimes is very helpful. Traveling. So a lot of times these individuals, they're receiving support for physical therapy, occupational therapy, whatever other types of medical treatment they might leave. But there's not much room or many finances left for them to go to the movies, to go to a baseball game, to go to the theater, whatever they might like to enjoy. So those are some things that some people might leave behind for them, but also a place to stay that a parent or grandparent or uncle or aunt knows will keep them safe. And sometimes that place to stay could turn into a group home where they have friends. And someone is coming into that home to care for all of those individuals. So we can get pretty creative with what we want to do for that individual to make sure that they're living a good life, but also not disrupting the benefits that they're receiving from the government. Because if we had to pay for those things out of pocket, I mean, unless you're pretty wealthy, it'd be difficult, honestly, to do. Do you have any other questions on the special needs trust? Yes, ma'am.
So can that trust be created after the fact? So just personally, we can have a special needs fund.
Mhm.
You know, the children acquire property after parents passed away, but have not been able to sell, or haven't been able to sell it because of what you
Mhm.
just said. If he gets his portion of this house that was only $60,000, now it's $500,000,
Mhm.
his benefits. So can this trust be created now, or would it have to be?
You can create it now, but the only type of trust that can be created for him would be that first party special needs trust. So my recommendation is as soon as you create that trust, you go ahead and spend the money to make sure there's nothing left. There are a number of things you can spend the money on, because if there's something left, it goes to reimburse the government, okay? So we want to spend it, and I don't know how old he is or what his life expectancy might be, but you want to spend it on things like housing if it's not covered. You want to spend it on medical support that he may not be getting. So sometimes the government will pay for 3 sessions of physical therapy or occupational therapy, but in the notes it could say that this individual could benefit from 5, right? So you pay for the extra 2. Or you go on family vacations, now this person can join us and you can actually pay someone to accompany him or her. Those are the types of things that you pay for through that special needs trust.
Now, when we say housing,
Mhm.
I'm sorry, if a sibling he's living with siblings to care for him,
Mhm.
can we still use housing for that?
Yeah, he can, right? Because if he wasn't staying with that sibling who may be allowing him to stay for free, he would have to pay rent. So sibling can charge him rent now, or could be doing that now anyway, but that special needs trust can pay for it. Mhm. You're welcome.
What about backward?
So you could do that. I would advise against it because we want to avoid the appearance of impropriety, right? So if I were the Social Security Disability Police, which they do go look at, you get audited just like you do for your regular taxes, okay? So you don't want to come in and say, oh, brother's been living with us for the last 10 years, and yes, we held this property because we didn't know what to do, but now that we know we could have been charging him all those 10 years, and now he owes us $100,000, right? So, yeah, so what I would say is moving forward, after you have that, the special needs trust established, you can go ahead and put the contract in effect now, but I wouldn't post-date it. Mhm. Yes, ma'am.
I don't know whether or not this is special needs. I worked for the county for almost 20 years,
Mhm.
and I got hurt coming out of the client's home.
Mm.
So I get disability from there. It blew my mind when they said, okay, so who will get it after you die? I mean, I was amazed that that happens. So I designated my daughter. She is a veteran. She gets disability.
Yeah.
So is any of that special needs?
So hers may not be, and we would just have to do a closer look to see exactly what she's getting her disability for.
She got hurt in the military,
So
and I don't know what the percentage is.
hers may be a little different because hers is a different type of entitlement, and they actually, the military, especially through, so I'm not talking about TRICARE. I'm talking about disability where she's being compensated for not being able to work. Yep.
She works.
Okay. And that's the key. So there are also different types of disabilities and disability benefits. And so some of this doesn't fall under what we're discussing, but if the individual cannot work because of their condition, this is the type of disability that I'm talking about. Usually those same individuals are also receiving financial support for treatment, medical treatment. So I would need to look into your situation a little more before I give you an answer. Yeah. Any other questions? Yes, ma'am.
You know the average cost of a nursing home is like $6,000 to $8,000 a month.
So, this is what I say. You can go to one as cheap as between $4,000 and $6,000, but do you want to stay there? Right? So I had to, we recently completed another round of my mother's estate planning. And when I took her to certain nursing homes, because I tell my clients, go tour them. Go select the one you want to stay in. And ask how much it costs right now, and then include some inflation, because it's going to increase every year. And so I don't say this is how much a nursing home it costs, because today's nursing home that you don't need to be in right now will cost more when you actually need to go. And so a lot of times, I recommend that my clients have long-term care plans. If they don't have the resources right now, they don't think they'll have the resources to fully cover the cost. And because of the assets that they have, they likely also won't qualify for Medicaid, and we have not created an irrevocable trust. So there's a lot of things to think about, especially in the final phases. The baby boomer generation and the generations before them, they're actually outliving their long-term care plans. And so you might need to think about getting a second one, because you'll live beyond what the policies were, because when they were making them back then, they weren't thinking you were going to live this long. So there are some people who thought about the future, but our industries hadn't caught up with our quality of life and standard of living. So those are some of the things we would talk about in our consultation. What are your future plans, and what plans have you already made?
So whatever income that you have coming in, the nursing home will take that
Yes, ma'am.
income and leave you with how much a month? You have any idea?
Sometimes nothing.
Oh, really?
Uh-huh. Yep. Sometimes nothing. Oh, you would be left with nothing. You could be left, depending on what you're getting. Yeah, I've seen that. Yes, ma'am.
That's state.
that was a specific disability that she's receiving. Usually, when someone is receiving disability, it ceases, those payments stop. Mhm.
But she's saying the state,
She has, it sounds like she has a special policy. Yep.
because I was thinking it stopped.
Usually it does. Mm-hmm. All right, next slide, please. So the next document we're going to discuss is a healthcare power of attorney. This document is drafted during your lifetime, and it is used for you to appoint a healthcare proxy. So if you become incapacitated, which means that you're not able to communicate your wishes or discuss things with your treating physician, this document will control how your care is managed. So you're appointing the healthcare proxy to speak for you. But in this document, you can be very specific about what you want to happen. So for example, would you like to receive artificial nutrition or hydration to prolong your life? Do you want to be resuscitated? What type of mental health treatment are you willing to receive? Would you like to age in place, which means stay at home or go to a facility? Would you like to donate your organs, donate your body to science? Do you want to be buried or cremated? And then if you have a very specific medical need, we talk about that and talk about what treatment might look like for you. And of course, this is after you've had those discussions with your doctors, right? So we're building that into your plan. Any questions about the healthcare power of attorney?
Does husband and wife both need it?
Yes,
Or
they do.
if you,
Mhm.
I'm gonna say, because the husband or wife could make the decision.
So that is true, right? You go into the hospital, the doctors will listen to the spouse. However, it's not just about the person, all those other things that I mentioned. The spouse sometimes isn't there to make that emergency decision. And with this document, we file it with the Secretary of State. And so it comes back with a driver's license size card that we advise that you keep in your wallet and then either in your car or someplace visible at home. It can be scanned, it has a QR code on it, so anyone who is with you can scan it, not just EMS. But we also ask you to give a copy to your primary care physician and take it to the hospital closest to your home. And so all of your decisions would be on that document, and we're not relying on spouse to pick up the phone from a stranger when an emergency happens.
But can you not do it at the hospital as a healthcare?
If you're competent, right? If you show up and you can't write because you had a stroke or you were in a car accident, then no. And now the doctor is making decisions for you because they are tasked with keeping you alive no matter what. Mm-hmm.
And it's also registered with the hospital.
Yes ma'am, it is. Any other questions about the healthcare power of attorney?
Don't hospitals and doctors' offices have their own?
They do. They have not all of them, but they have very generic versions that you would have to write in some of the things that we talked about, but usually attorneys are drafting more detailed forms. But yes, not all doctors' offices, all hospitals should have them. And quite frankly, if you have had a surgery, you should have been asked to complete one. I'm learning that that's not always the case, but you shouldn't go into a major surgery without completing a healthcare power of attorney. Next slide, please. So the next document is the durable power of attorney. So this document is appointing someone who would manage your financial and business affairs if you're not able to do so for yourself. This person has a lot of discretion to have control over your assets. These are the assets that you leave outside of a trust, okay? If you have a trust, your trustee is controlling everything that is in that trust. If you don't have a trust or you have a trust and leave assets outside that trust, this durable power of attorney controls all of those assets. And this person is able to take your assets, they can sell them, they can spend your money, they can enter into contracts on your behalf. This should be someone that you trust to manage everything for you, and you have seen it being done. They've done it for themselves and maybe even for other people. They also need to know how to add and subtract, okay? Because you'll see some, you can't always pick your favorite person, right? That might not be the appropriate person to pick for the job. Just like with the healthcare power of attorney, you need to pick someone who is going to answer the phone when people call. They will drop what they're doing and show up at the hospital for you and be a partner with the medical provider to make decisions. Can't be someone who is kind of flaky when it comes to, you'll see how people handle arguments, because when people have to use these documents, a lot of people start having opinions. So the people you choose to stand in these fiduciary positions should be able to stand firm in whatever decision you have made, and you need to be able to trust them to make the decision that you have made in these documents. So it might not be your best friend, right? It might not be your child. It might not be your sibling. And so you have to think about that and then let the attorney have those tough discussions. You can put it on us. I take the flak all the time. But that's how you should be thinking when you're choosing your fiduciaries in these situations. Next slide, please. Okay, so we talked about the healthcare power of attorney and the durable power of attorney. Together, they are equivalent to a court-ordered guardianship. And so I'll discuss what a guardianship is. A guardianship is a court order, or it's a court proceeding that happens that ends in a court order appointing someone as the guardian. There are three types of guardians. The guardian of the person, who controls what happens with your body. That's equivalent to a healthcare power of attorney. And then there's a guardian of your estate, who is controlling what happens with all of your stuff, okay? And then you can have a general guardian. That person has two jobs. They're controlling what happens with your body. They're controlling what happens with your assets. So they have two roles. If you have a healthcare power of attorney and a durable power of attorney, the court will dismiss a guardianship action because you've already designated someone to serve in that capacity. So oftentimes, I'm actually a court-ordered guardian ad litem. And this is what my clients look like. They look like an elderly person who has succumbed to some type of disorder where they cannot manage their own affairs, they cannot take care of themselves, and either no one has stepped up to do it, or someone has stepped up and done it and is likely mismanaging their health care and or their finances. That's usually how they get to me. DSS has filed a complaint, somebody in the neighborhood has filed a complaint, or they have children who live too far away, no children, or children who do not have the capacity to care for a parent. There are also some people who, they've just been so mean over their lifetime, nobody wants to do the job. I'll be frank. But this guardianship process is something you do want to avoid, because what happens is a guardian ad litem comes in to make an assessment. They've usually only met with you a few times because they have a very short time span to complete their report to the court. And only the people who show up and answer the questions are the considerations I'm able to make in that moment, right? So if the best person for the job doesn't speak to me in the time frame that's necessary, I won't be able to consider them. Or sometimes there's so many people that do care, I have to make a decision about who might be the best person. The judge will too, and it actually might not be the best person, right? I can only make a recommendation based on the information that I receive. So if you suspect or you care that if in your old age you will not be able to take care of yourself, you need to have these documents drafted so that you can appoint who would manage your affairs. So that's your health care and anything else you leave outside of a trust. These documents are very important. I've already mentioned how baby boomers are living longer. They are living longer, but some of them are living outside of the realm of their right mind. And the likelihood that will happen, even if it's for a short period of time, is pretty high. Do I have any questions about either one of the documents or the guardianship process?
Can you change them?
Absolutely. Just like the question with the will, all of these documents, except for an irrevocable trust, you can change them at any time. Next slide, please. The next document is a HIPAA waiver. And most people know what HIPAA does. It protects our healthcare rights, right? So no one can see what's going on with us at the doctor's office or at the hospital. This is a waiver. You're waiving that right. And you're waiving the ability for a few select people to get access to that information. And let me paint the picture for you on why you might want to do it. Who went on an amazing summer vacation? Anybody? Okay, I see one hand. Where'd you go? Who went on an amazing summer vacation? Okay, you went to Canada. Where'd you go? Mm-hmm. Key West. Okay. Canada. Okay, so did y'all go together? Yes, okay. So, and are you guys sisters or friends? I'm sorry? Friends, okay. So this will fit into my example very well. So we have two friends who I'm assuming flew to Canada. Yes? No, you drove? No, I said two friends who flew. You took the bus? Okay. They took the bus to Canada. Okay? And we're not talking about them, we're just talking about some other friends, okay? So they took the bus to Canada. They planned to stay for 12 days, and the bus was in an accident. It actually got hit by a truck. One of them had to go to the hospital, okay? They're friends, they spend a lot of time together. They may not discuss all of their medical history, but one of them had to be rushed to the hospital. When we get there, the doctor says, is she diabetic? Is she allergic to this medicine? And has she ever had a reaction to this? And you say, I don't know. How many of you know that information about your friends? So this HIPAA waiver would allow friend number 2 to call the hospital here or call the primary care physician here and get that information immediately for that doctor to provide that prescription. That's how a HIPAA waiver works. Someone has the authority to gather that information to help a doctor make a decision, okay? That's what that looks like. This document, I would say, goes hand in hand with that healthcare power of attorney, okay? And I've had a few clients actually use this document, whether they're going to visit children, right? They're just going for a couple of months or a couple of days, and their children may not even know about all of their prescriptions and things like that. And so having this document is very helpful, and I have clients where it has saved their life. Okay, next slide, please. Okay, so y'all had a lot of questions about real property, and that's what we're gonna talk about next. So how to protect real property, and a trust is not the only way to do it. Next slide, please. So in North Carolina, we are actually one of the few states that allows for, it's called an enhanced life estate deed, or a ladybird deed is what it's affectionately called. What it looks like, or what it does, is it allows you to maintain lifetime rights of the property that you purchased. So as long as you're living there, or you want to live there, you could also live somewhere else, but you have ownership rights to that home. The moment you pass away, the beneficiary that you're leaving that property to absorbs your interest. So it, in effect, creates the same type of relationship that a husband and wife have when they own a home together. That's the only other time you can see this situation happen, through the creation of a ladybird deed or husband and wife who have purchased a house together when they were married. The benefit of this ladybird deed, especially when the house might be your only big asset, is that if you create this deed before we have to start the 5-year look back period, you have preserved your home. Because Medicaid cannot consider this document because you have created a future interest in your beneficiary, okay? So if your house is your largest asset, and for some people, as they age, they're just relying on their retirement, that one retirement check, right? They have set income, they're okay. They can pay for their food, they don't have a mortgage, there's not much left in their personal property. But because you live in Gastonia, that house you purchased for $70,000 is now $700,000. So a ladybird deed is something to consider. You can sell the house, but the value of the house, depending on your age, when you sell it, may not be as much. And I say this because with that deed that you would transfer to someone else, it's only good for your lifetime. So if you're 80 years old trying to sell the house, we may only have about 20 more years or less for someone to own what you own, which is a lifetime interest in the property. Does that make sense? Yep. Okay, so I'm gonna use, it looks like he snuck away, but I'm gonna use my son, okay, he must be there taking a nap. Robert, as my example. Say I bought a house, right? I bought it for $100,000 5 years ago. And I leave Robert as my beneficiary or the recipient of, it's called a remainderment. So all of my life, for as long as I live, I own the home. It is mine to do whatever I want to with it, just like you're doing with your house now. At the moment I pass away, Robert is now the owner. He absorbed all of my interest in the house. Now, if I die young and didn't need Medicaid anyway, then we're fine. But let's say I died at age 78, right? Then I could have needed Medicaid during that time. But let's say I made the deed when I was in my 30s. So I did it well before that 5-year look back period. Robert's interest is now vested. It invests after that, the 5-year look back period, all right? So when I pass away, Robert has absorbed my interest. But during that time, from when I made that deed to when I passed away, I could have given my lifetime rights, that 30-odd years, to someone else. I could have sold it. I could have rented it. During that 30-year period, while I'm still alive, after I've made that deed, I can do whatever I want to. But the value of that is going to be less than giving someone what's called fee simple, where they own it indefinitely, because they only get the value of my lifetime. Once I die, it all goes to Robert. He's the remainder man who will keep the final interest and receive that fee simple. So most of you who have a deed with a mortgage company, you have a deed of trust. After you pay off your mortgage, there's another deed that you actually get. So they post that you've paid off that mortgage, that loan, and now you have a fee simple. The fee simple means that you own that home indefinitely and can pass on rights to anybody else that you want to. What you create here in the beneficiary, they get a fee simple. So you're taking that away from yourself. You only get lifetime rights. So the only thing you can give away are your lifetime rights. So when you die, if someone purchased your interest, their interest also ceases to exist when you pass away. Does that make sense? So once you create this, you have two tracks. So you hold on to it, and it goes to, for me, it would go to Robert. Or you can sell it, but what you're selling is your lifetime interest or right in that property. Nothing more, nothing less. Does that make sense?
It does, I don't understand it, I'm like, what's the benefit?
So the benefit, so I do have some people who rent it, right? They want to go live somewhere else. They're maybe go live with children, and you can rent what you have, your lifetime interest, because maybe someone else wants to stay in the home and they're willing to pay you for it until you pass away.
Is that what the title insurance is? You gotta make sure that no one has inherited the house.
Right. So the title insurance is looking for that, and it's looking for any other issues with title, like encumbrances that you may have given someone, an easement. So it's looking for other things, but yes, that is one of the things that the title insurance is looking to cover. And I'm happy to have this discussion a little deeper with anyone who wants to discuss it as an option, because I do think it's a good option for individuals where the house is one of your greatest assets. South Carolina is actually one of the states that does not acknowledge Lady Bird deeds. North Carolina is one of I think there's only 5 or 6 states that actually acknowledge this type of deed. Yes, ma'am.
So what's his benefit? I still don't understand what the benefit is.
So the benefit is that you could qualify for Medicaid. So we talked about that spin down. Some people are forced to sell their house to qualify for Medicaid. If you create this before the 5-year look back, you won't be forced to sell your house because someone has a future interest in that house. Also, for this, if your house is one of your greatest assets and you make this transfer, this completely avoids probate. This house will not be able to be brought into probate to pay your creditors. So there are some benefits to doing this if you do it within that 5-year look back period.
I do have a question.
Yes, ma'am.
It seems like it's happening now where scammers are coming and saying that they're the person and taking their home.
Yeah.
So you got any information on that?
So other than just checking to make sure, and you can actually check your deed yourself on the Register of Deeds website, or every so often walk into the Register of Deeds and they'll answer your questions.
Okay.
Yep, they're happy to. Yes, sir.
Like if we hire you or
Mhm.
whatever, you go through all this and say, like if I wanna do a trust
Mhm.
through your firm or whatever, some of this, you go through it during the custom.
I do. I have it's not the exact presentation, but a similar presentation.
Yeah, okay.
Mhm.
And you can create all these documents for us.
Yes. Mhm. All the,
Can you kind of give us a ballpark cost, if you don't mind, or you don't want to share that?
so no, I'm happy to share it. So it depends on whether it's for husband and wife or a single person, and then also the documents you're selecting. So for the package for all the documents that we're talking about, I'll say it would range anywhere between 4,000 to 7,000 depending on what you're getting, and then also additional services that we offer. Mhm. And we usually ask for half upfront to get started, and then the other half when you're ready to sign. And then we are filing all the documents at the various government entities, and then you would come back to us once we get those back, and we're doing what's called a binder delivery. Next slide, please. You can also, we've talked about this process, transfer your real property after you've passed away. We have to go through that probate process first, because that's required. And again, that's a lengthy process. We have to wait for the notice to creditors period to run and hope that no one challenges your will, which happens more often than you might think. And then we can transfer that real property. That's what that looks like. if you have a will. And it's a very similar process if you don't have a will. We still have to go through that probate process first. Next slide, please. We can also transfer your real property through a trust, and we've talked about that already. If you place it inside the trust, then your trustee will manage that property. So let's say you decide you want that property to be rented. It can continue to make income for your beneficiaries, and your beneficiaries will receive that income. Or you can transfer it to those beneficiaries outright if you would choose to. I think a trust is a great way, if you have minor children, to protect those assets to make sure they can still have use of it until they reach the age of majority, whichever age that might be to you, because in the trust you get to determine what that age is. Next slide, please. Okay, so I've had this question a few times, and this is a timeline of what estate planning should look like based on your phase of life, not your age, but the phase. So when a baby is born, parents should definitely have their own estate plan. They should also be considering a 529 plan and a life insurance policy for that child. At the very least, to make sure there's some support if they anticipate putting that child through post-secondary college, right? You're going to college. Or if that child should pass away, you want to make sure you have enough life insurance to bury them. So let's say when your child turns 18, most parents don't know, you cannot actually go into a hospital and make decisions for your child. You are no longer the person who controls what happens with them when they turn 18. And a lot of people who send their children off to college learn that the hard way, because the first time something happens and they come in, the doctor may not take your recommendation. It might be that your son or daughter has already indicated some other person to make a recommendation. So at the very least, when your child turns 18 years old, they should have a healthcare power of attorney, a durable power of attorney, and a will, just in case. Now, as this child ages and becomes a professional and starts to amass their own things, they get their own house, they start to have their own children. So this is where I am, right? I have my own children, I own a few things, but I'm also figuring out how to care for my mom. So at this phase, you want to make sure that you have a revocable trust, so just in case something happens, right? I have a trustee who can take care of my children. I have a trustee who can also take care of my mom, and I feel good about the people I've selected at this phase of life. You also want to, because I talked about having children, the men in your life need to make some type of proclamation about their children, if they haven't. If they have had children outside of marriage, they want to legitimize that child either through a court process that's called legitimation, or they have signed some document, whether it's court-ordered child support, but it has to be an affidavit that is notarized, okay? And if you have questions about how to do that, you can call me. They can also help you through that process at the clerk's office. But make sure you do it, because that's something really painful for me to have to go through when I know it's in the intent of the father to actually care for the child. But the court's not going to enforce it. So once we reach this pre-retirement phase, which I hope to enter really soon, but I don't know, this one might keep me in the game a little longer than I had anticipated. But we are thinking about getting things out of our name. Whether that is through an irrevocable trust, we are transferring those assets to someone else that we trust, which is something I don't necessarily recommend. We can talk about that. We're also talking about long-term care, making sure we have enough, making sure the plan that we have will last us our entire lifetime. And then we're also thinking about funeral plans. You can get a prepaid burial or a cremation plan, but you want to make sure that the plans that you're making also include the small things. So we help do that. We have a form that you can complete So you know, or your loved ones will know who should be contacted. Maybe you want to have the Rolls Royce of caskets, or you just want a little wooden box. Share that information so we know how much to spend on your funeral, right? Or your memorial, or maybe you don't want one. People are getting very creative with how they want their life to be celebrated. With the money they're leaving behind, they're sending their whole family on vacations in their honor. There are a lot of things you can do. But make those plans, because that is one of your last acts of love, to not have someone labor over what you would have wanted, what you want to be said, how you want to be remembered. You can make all of that while you're still here. And then lastly, when you are in your retirement phase, you just don't want any assets in your name. Because if you need to qualify for Medicaid, that 5-year look-back period will certainly prevent you from doing so immediately. And so we can talk about the ways that you would be able to do this, but this is what I recommend for my clients who are coming to me in that retirement phase. So I have a few other slides after this. This can certainly be our stopping point. Those other slides are about business. Is anyone in here a business owner, or would you like for me to discuss that? No? Yeah, I have a question. Or you would like for me to discuss that? Yes, sir.
I have a question.
Yes, sir.
So back up to the legitimacy of the child.
I'm sorry.
Back up to the legitimacy of the child.
Yes.
Legitimize the child.
Mhm.
Would the birth certificate count as a document if you sign it? And it's
Your birth, yes, your birth certificate. Check to see, because I don't know where the child was born, but most birth certificates are notarized at the Register of Deeds.
so that would
Yes.
qualify.
Mhm. Oh, sorry. Yes.
What does Medicare do in regards to nursing home care? Are they involved?
That's a
or
good
is it
question.
Medicaid?
So, when we talk about Medicaid, Medicaid is paying for your housing at that, at the facility, okay? And when I say housing, long-term housing, not you have gone into rehab, okay? There's a difference. When you go to rehab, Medicare is paying for your medical care. When you have to go to a nursing home where you will stay indefinitely, Medicaid is paying for your housing. Medicare is paying for whatever treatment you might receive at your housing. So most people need both if they can't afford to stay at the nursing home with whatever retirement or proceeds that they're receiving on their own.
Okay.
Okay? That's a good question.
Thank you.
Mm-hmm. I'm okay. We have two more slides left. Thank you.
This is about to ask, so is it the price cheaper for you single than if you married?
You mean my price?
Yes, ma'am.
Yes, because if you're married, then I'm completing 2 sets of documents that may not, and oftentimes is not identical. Yes, ma'am.
To go along with that, since, people want to know about your rate, do you make any type of rate adjustments for those that are on, Medicaid?
I do.
Okay.
Mm-hmm. I do. One of the things so we've talked about, right, people in our community are not making these estate plans, so price is not going to be the determining factor of you getting these plans at our firm. Maybe somewhere else, but not ours. So we try to work with you to make sure that you get the plans, because that's really important to us. Next slide, please. Okay, so business succession planning is essentially doing all the things we talked about for yourself. You're doing it for your business. What does it look like when you reach the age of retirement? Who's gonna run your business? Or if you decide that you no longer want the business to run, who's gonna wind it down for you? If you pass away unexpectedly, what's going to happen to your business? Is it going to continue on so it can provide for your family? Are you going to sell it to someone else, or are we going to wind it down? And in going through this process, we need to know key players within your business who are assisting you with making your business continue on, right? Who are you working with right now? Who's gonna have all those company secrets so that we can make sure that your business continues to boom while you're no longer here? So we're talking about the employees, we're talking about stakeholders, and what role each person has to play with your business. Next slide, please. And then we're going through and asking you the questions that I mentioned. Who would manage your business if you become sick? Most business owners can't tell me that unless their spouse is also working in the business. And sometimes the spouse doesn't want to work in that business if the other spouse is no longer there. Who would take over your business if you were to pass away? Or what would the transition look like? Sometimes you have a key employee who could step in, but what type of compensation are you offering them to do that? Would they have to buy into the business? And then would the business continue on? Would it be sold? Would you dissolve it? And then if so, who's going to do that? Now you can hire an attorney to do those things, but you can also appoint someone who can do many of those same things and maybe get advice from an attorney to make sure that they've done it correctly. But you certainly want to have a plan for your business. And then we want to know about equity stakeholders. Maybe you have investors who have made investments into your business and they'll have to be paid off. What does that look like? Next slide, please. So I hope I have impressed upon you that it is important to have an estate plan. And it's important to make that plan now when you're alive and well, as opposed to waiting until something tragic happens or just until you run out of time. And I don't mean time as in your life, but time as in when you yourself can make decisions for yourself. Next slide, please. And so if you need to contact me, we offer virtual appointments. So I can meet you on your computer, I can meet you in person, whether, again, that's your home, one of my offices, or some other location. And then we also do emergency estate planning. We do that pretty often. If it's not me, then a paralegal would meet someone in the hospital to gather information. And you can reach us by telephone, email, or at our website, www.hicksgwinlaw.com. And I want to thank you all for being so engaging during this presentation. You had a lot of really wonderful questions. Thank you. January the 12th. Yeah, so I have a little while to go. Yes, sir, I do. They're right here. And then I also
Everyone, please, if you do not have your business in order, please get your business in order, okay? I approve the message that she gave today because I've been through probate with my dad. When she talked about doing the spin down, I've been there. So she's telling you the truth. Everything she spoke today, she is spot on. So please take that seat.